சார் இனிமே அட்மிட் பண்றதை நீங்க பாத்துக்கங்க.
ஓகே சார்.
ஓகே.
சார் ரீவாவை அட்மிட் பண்ணும் சார். Sir, I think Reva's in, sir. Hello?
He will do, ma. Actually, live is going on.
Oh, okay. Sorry.
Okay. You're also, I made you co-worker. You can also do it, right? Okay.
Okay, sir. Sir, I think Reva is on mute. I mean, I think she's not able to unmute herself.
Yeah, hello.
Sir.
Live is going on, yeah. Okay. I think I have unmuted Reva.
Yes, sir. And yeah.
Indian
yeah,
sir,
she's
Indian
in.
Sir, yeah.
Hold on, son.
Sir. Hemakumar sir.
Yes, sir.
Indian sir, co-host மாத்துங்களா? Okay.
இதெல்லாம் லைவ்ல போயிட்டு இருக்கு சார். Okay, no problem.
Sir, can you unmute Reva, sir?
It's done.
Okay, sir, I'll do the introduction as well.
Okay. This time is 3:31. Shall we start?
Yes, sir.
Hemakumar sir, Indian sir.
Yes, sir, we can start.
Yes, sir.
Okay. So good afternoon, participants. Once again, welcome you for the third day of our Social Security Legislation Certificate course. Now let me call upon Swarmya Rao to welcome the gathering and also introduce the resource person of the day.
Good evening. Welcome to today's session. I welcome our resource person for today, Professor Hemakumar, and it is a pleasure to have you, sir. I welcome all the participants, and I hope you have a great learning session today. Professor Hemakumar is presently heading the postgraduate diploma in personnel management and industrial relations department, and also is the assistant professor of Department of Human Resource Management in Madras School of Social Work. He worked as a HR for 2 years in industries. He holds 8 years of teaching experience. He has completed MA HRM and MPhil HRM in St. Joseph College and MA LM in Madurai Kamaraj University. He's also a qualified UGC of NET. He acquired advanced labor law certification from CII. He also completed people analytics certificate from University of Pennsylvania. Thank you, sir.
Thank you, Swarnima. Okay, let's move on to quickly the Payment of Gratuity Act 1972. So this is the scope of my presentation: brief introduction of the Act and meaning of Social Security, definitions, nominations, forfeiture of gratuity, continuous service, payment of gratuity, recovery of gratuity and inspectors, determination of amount of gratuity, and the penalties, protection of gratuity. Okay, fine. So last 2 days, actually, we have seen Social Security. Of course, the first day, Madam also explained about what is Social Security. But here, I'll give a brief a definition of what is Social Security. See, Social Security is nothing but to meet, social means normally family, to secure the family. Okay, what is the secure family in terms of contingency? In the days of contingency, he and himself, take care of the family. That is the reason, they need some Social Security. Social Security combines social assistance and insurance. Of course, there is a definition for Social Security. Here, contingency of modern life sickness, unemployment, old age, dependency, industrial accidents, and invalidism against which the individual cannot be expected to protect himself and his family, but his own ability or foresight. This is a crux of this definition. And of course, the Social Security combines two things: social assistance and social insurance. You must understand what is social insurance. See, normally, insurance means what normal people will give some premium for contribution for the insurance agency. Thereby, in turn, they will receive some sort of benefit during the employment or post-employment, or after the premium gets over, they'll get some lump sum amount in social insurance. Social assistance here, it's a supplementary of social insurance. Okay, like government will give all the social assistance to the normal people. For example, old age pension and maternity pension also. Likewise, here the Act is clearly defined what is Social Security is, and also the social assistance and Social Security. Now let's move on how this will be applicable to our Act. Okay, so Social Security, again, this is my interpretation. I have classified into two things: social assistance and social insurance. Here, those acts which come under the social insurance is Employee State Insurance Act 1948 and the Provident Fund Act 1952. And here, why it is mentioned under social insurance means, yesterday, and day before yesterday and yesterday also we had seen there will be a contribution. So in return, as a contribution in the way of premium or subscription, in return, they will get some benefits out of the contingency. Of course, we have seen in detail about different benefits under the ESA Act and different benefits under the Provident Fund Act. So here, the contribution will be done by both employer and employee. Thereby, in turn, the employee will attain the benefit or will enjoy the benefit out of this social insurance. Okay, moving on to the Social Assistance Act. Here, the employee will not spend a single pie from his own pocket. Here, let us take a Maternity Benefit Act 1961, Gratuity Act 1972, Employees Compensation Act. Here, there is no contribution at all. Then you might ask this question, sir, why do we need the employer should burden for providing all the social assistance? Sir, there are a lot of labor welfare theories which makes employers to provide a social assistance. Of course, if you take the Social Assistance Act, Maternity Benefit Act, Gratuity Act, Employees Compensation Act, which is also listed in the Constitution of India. Okay, let's move on to now. One such act which we are going to define is Gratuity Act 1972. It's one of the Social Assistance Act. Okay, let's move on to the brief introduction of the Act. The Act passed in the year 21 August 1971 and came into force 16 September 1972. This Act is drew the inspiration from Kerala Industrial Employees Payment of Gratuity Act and the West Bengal Employees Payment of Compulsory Gratuity Act. But largely, it drew the inspiration from the West Bengal Employees Payment of Compulsory Gratuity Act 1971. And of course, some Section 5 of the Working Journalist also speaks about payment of Gratuity Act. This is a brief introduction. Let's move on quickly about the definitions. Okay, here definitions is application. Every establishment which has 10 or more persons, I just italicize, the persons are employed. If any organization has 10 or more employee, this act will be applicable automatically. Okay, let's move to the definition of employee. Employee means here any person who's employed for wages. Just note the word employed. For wages, terms of such employment are expressed or implied in any kind of work or manual. Terms of express or implied means their appointment order will tell about the terms and express, and also but does not include central and state government employees, and statutory apprentice, nothing but the apprentice who's covered under the Apprentice Act 1961, and contract labor in relation to the principal employer. This subject of disputed provisions here, whether principal employer is eligible, liable to pay gratuity. First of all, we must understand who is the principal employer. Suppose if any employer gives a portion of amount to the second person, which the second person, the employee is some of the persons, no? For the employee, some of the persons, that person, second person is immediate employer. The person who gave a portion of job, that's called principal employer. That's the meaning of the principal employer. Let's move to the employer means. Okay, definition of employer. Here, employer means one who has ultimate control over the affairs. Very simple. Whoever has the ultimate control over the affairs, he or she is known as employer. Okay, wages. Wages means includes all emoluments and DA, but does not include bonus, commission, HRA, OT, and other ones. Yes, it's very clear. Only all emoluments and DA. Here they are mentioning about basic plus DA. No gross. Okay, that's why they are very clear about does not include any bonus, commission, HRA, and any other allowance. So the wage definitions clearly mention about the basic of the act. Okay, next is controlling authority, who is appointed by the appropriate government responsible for the enforcing act. This is very, very important. We should note about the controlling authority. He is the one who administered the act. He is the one who is to govern the act. And also any disputes, the employer and employee should first approach the controlling authority. Let's move on to the definition of complete years of service. Here, it means it's a 1 year of service. Okay, we'll discuss more about the complete years of service. Okay, let's move on to the appropriate government. So appropriate government in relation to the establishment having more than one having more than one branches, major port, mine, oil field, railway company, the central government, otherwise state government. Okay, very simple. If any organization has more than one branches across India, central government will be appropriate government. Otherwise, state government is a appropriate government pertaining to this legislations. Okay, let's move to the definition of family. Okay, so many of them might be wonder, yesterday also we saw family, and yesterday also we have seen the definition of family. See, you need to understand the line of the social security. So if there is any contingency, they have to give some sort of amount to the beneficiaries, so-called dependents, so-called family. That is the reason, if you see across all the Social Security Act, there will be a definition of family, there will be a definition of dependents. Okay, over here, the Act has also prescribed who is the family, which is specified in the section 2H of the Act. In case of male employee, himself, wife, children, married or unmarried, dependent parents, and his wife's dependent parents, it's so-called in-laws, mother-in-law, father-in-laws, and widow, of course, and children of his predecessor son. Over to a female employee, herself, husband, children, and dependent parents, and her husband's dependent parents, and children of her predecessor daughter. So, in case of any contingency, in case of any eventualities, it is employee, both male employee or female employee should give who's a family in the prescribed format. Okay, that we'll discuss later. Okay, let's move to the next important definition is continuous service. Okay, continuous service is specified in section 2 capital A, means is uninterrupted services, which means there should not be any interruption in your service. So you might have wondered what is the reason behind giving continuous service while calculating for gratuity, that we will see the term continuous service. That is the reason the Act has prescribed what is continuous service. Here, it has been classified in two, which is applicable to seasonal employment and also non-seasonable employment. So seasonal employment here means which in a calendar year it will not functioning more than 120 days in a calendar year, that is 12 months. Okay, it may be circus or any other construction industry or any other in the while constructing the road. Definitely they will come under the purview of the seasonal employment. If they will not work more than 120 days in the 12 days, that is calendar years. Okay, here see, non-seasonal employment is nothing but what the general person we are working any institutions like TCS, TSS, that is called non-seasonal employment, which means employment. Okay, let's move to the crux of the meaning of continuous service. So while calculating the gratuity, there should not be any interrupted services. Interrupted services here they are given a inclusion. So sickness, definitely there'll be interruption of service, accident, interruption of services, and leave authorized services, and layoff or lockout aside, which should be an authorized one, and cessation of work on the part of not default of the employee, and exclusion, absence in respect of which an order passed treating the absence as a break of service in accordance with the standing orders. See, anything is unauthorized absent, anything is which is mentioned in the standing orders, it's called unauthorized absent. In that case, that unauthorized absence will not deemed to be continuous service. Okay, so inclusion, if the continuous service, there is an interruption in the following criteria, that is also will be taken to consideration for the continuous service. Okay, here in the 1 year, if any employee is 1 year, 240 days, in 190 days below the ground in mine or establishment less than 6 days in a year week. If it is 6 months, 95 days below the ground in mine, 120 days in other case. Or to here, seasonal establishment, if it is not less than 70% of total number of days on which establishment was in operation, that is called a continuous service with regard to this act while calculating gratuity. Okay, let's move to the next slide. Eligibility criteria. When employee is eligible for gratuity. So normally, any employee who has rendered continuously for 5 years, that particular employee is eligible for gratuity. The 5 years will not applicable for the certain races. In case of death, in case of disablement, the 5 years conditions will not applicable for those employees. Those employees can enjoy those disabled employees. The deceased employees family will receive the gratuity amount. Okay, so next is the 5 years service. Under this, there is a special case over here. 5 years case is not necessary. Okay, here there's a case here. This is famous case which gave a historical verdict here. If any employee works 4 years, 240 years, continuous service. So continuous service, they are also eligible for gratuity. So that's why in the here employee who has rendered continuous service, I just italicized, which we discussed in the previous slide. What is continuous service? Okay, this is eligibility criteria for gratuity. Next is formula for calculating gratuity. So once the employee is eligible, now how to calculate gratuity? So here the formula is last done salary into number of completed days of service into 15 divided by 26. This is the formula for gratuity. The last done salary is nothing but basic plus DA. So number of completed service, number of services completed service. Please note here completed service. So anyone workers 6 years is completed service, and last done salary into 15 divided by 26. This is the basic formula for calculating gratuity. Okay, what is the amount, maximum amount can gratuity can be given? It's a 20 lakhs with effect from 29/3/2018. Previously, it was 10 lakhs. So this is a simple explanation of about formula for calculating gratuity. Okay, let's move to the next definition. Yeah, forfeiture of gratuity. So I think you can see here the picture over here. It's a famous comedy scene. I think majority from North India. I think I need to explain this here. This person, this person is plotting a plan to stop his sister's daughter's marriage. He was plotting the plan along with these associates, so-called employees. He's a boss. Okay, the majority of the Tamil people will know about this comedy, but still, I need to explain here. Okay, so this guy, as a so enthusiastic guy, what he has done, he has stolen the comb of the bridegroom, so that the bridegroom will look shabby. He will not come to the marriage dais, so the marriage will be stopped. That is the funny thing, here mentioned. But immediately the boss gave the punishment. Immediately the boss gave the punishment. Okay, you might wonder, sir, what is that? The analogy between the forfeiture of gratuity and this picture. See, just a small thing, of course, it's an offense. Stealing, it's an offense. Theft is an offense. But the punishment should be commensurate with the offense, commensurate with the theft. Over here, the forfeiture of gratuity, section 4 fix, which means the employer, when the employee will be forfeiture of gratuity. Okay, the Supreme Court is clearly mentioned is forfeiture of gratuity and dismissal of service not automatic, which means here when employee is terminated as a riotous or disorderly conduct, any other act of violence on his part, or any act with constitution of offense involving moral turpitude, but provided subject to is committed during employment, proper inquiry of the said misconduct. You see this picture here, there won't be any proper misconduct. Of course, this guy punished for this funny idea, but in reality, there must be a proper inquiry of the said misconducts, even if it's theft or subordination of the property. See, the disorderly conduct is not about damaging the property, but everything to the extent the damage of the property, the gratuity should be reduced. Okay, when the complete denial of the forfeiture of gratuity, that is comes under the case over here. Here, any other act of violence, any act which constitutes an offense involving moral turpitude. Okay, so in that case, gratuity can be denied. So if you take the example of this case study, okay, this bank manager, okay, has looted all, not looted, is failed all his duty. So in that case, what they have done, they have just dismissed and they forfeited gratuity when he approached High Court, and whatever said misconduct of him should be an offense by the criminal law, and the court must give a punishment. Court must give a punishment. Then only it is called moral turpitude. Then only the forfeiture can be, gratuity can be forfeited. Then only the gratuity can be denied. Okay, that is the essence of this forfeiture of gratuity. When employees, this is the rights of the employer. Thereby, employer has to forfeit. Employer can forfeit the gratuity. Okay, but for any gratuity, for any forfeiture or punishment, proper inquiry must be conducted. What is the proper inquiry? Show cause notice to be provided, and also the principles of natural justice should also be employed. And the employer should comply with the principles of natural justice. Then only you take a call. Even forfeiting the theft, there must be a this one. There must be a separate inquiry, and also principles of natural justice. The employer also sent a separate notice for forfeiture in gratuity. Why your gratuity shall not be forfeiture? That is also a proper inquiry, and the principles of natural justice should be complied. Okay, let's move to the next definition. Determine of the amount of the gratuity. Okay, now employee has standard completed service, 5 years completed service, or 4 years to 40 days. Okay, now he has to receive the amount. Okay, what's the time limit? Before 30 days. Before 30 days, the moment he is about to retire or resign, he has to apply form number I. Okay, within 30 days, the employee. This 30 days will also applicable to the employer. Within 15 days, the employer has to calculate the amount and submit to the employee. And after 15 days, settle the gratuity amount by way of bank transaction or check. Okay, so here the determinant of amount gratuity here is the employer's responsibility to give notice, that is 15 days, to concerned employee and controlling authority. I don't think so. Employees are giving a notice to the controlling authority, but as per the act, when they are determining the amount of gratuity, they have to give a notice to the employee as well as the controlling authority, because in case of any dispute, because in case of any dispute, the controlling authority will be there to sort out the dispute. Okay, yeah. In case of dispute, deposit the amount to the controlling authority and fine. If employer has delayed, the controlling authority or appellate authority can condone the delay. So in the default, simple interest 10% along with the gratuity amount should be deposited in the employees or dependents account. Okay, appeal. If there is a concept called appellate authority, of course the act also not defined the appellate authority. There is a third person, say employer, employee, controlling authority, and one more person is called appellate authority. So if there is an appeal on agreements of the order by the controlling authority, both employer and employee can approach the appellate authority. So the appeal should be done within 60 days of the receipt of the controlling authority's order. Okay, then the appellate authority should take another 60 days. So maximum within 22 days, this case should be dissolved or stalled. Okay, that is the determinant of the amount of the gratuity. Okay, let's move to the next section. Compulsory insurance. So this act prescribed under section 4A is compulsory insurance. Okay, every employee shall obtain an insurance for his liability to payment towards the gratuity from LIC after the appropriate government's notification. But here, when there are 500 or more employees, of course, the employer should comply with this section. But here in Tamil Nadu government, the government has not yet notified this particular definite provisions of the act. Whereas I just checked, only the Andhra Pradesh government has notified compulsory gratuity insurance rules, published the notification so and so on that date. Okay, see, normally it is better. Apart from compulsory insurance, any employee has tied up with the LIC or any other insurance agency group gratuity, the burden of paying amount will not be there. Okay, so if you don't tie up with any, that employer does not tie up with any insurance company, then the burden will be huge and they have to burn their own pocket. Okay, so in that case, the employee better to tie up with the insurance agency, group insurance agency, because they will calculate all the death or disablement and gratuity amount. Okay, and also they will take off anything. Only thing is the organization should govern the trust. They have to create the trust, and from the trust they have to approach the LIC, whereby the trust will administer the act in the institution for payment of gratuity and so on. Okay, next move on to the nomination section 6. So each employee who has completed 1 year of service make a nominee within 30 days. Form F, under Form F, there's a form which is specified in the rules of the act. we have Tamil Nadu Gratuity Rules 1973. We have it is mentioned 30 days. Before that, before this is after commencement of Act 30 days. But there was a provision. If there is no before the commencement of Act, it is 90 days. Now we need not worry about 90 days. Now we have to stick on with only 30 days. So they have to make a nominee within 30 days as soon as he got the employment. Okay. Now let's move to the next step part. An employee may distribute the amount of gratuity payable to him under the Act amongst more than one nominee. Yes, in Form F, it is clearly in the Form F, it's clearly defined. What is the proportionate of amount you want to share? Okay, the distribute amount. In case of wife, mother, father, son, daughter, everything is there. Okay, next is while making nomination, if the person does not have a nominee, or if he or she make any person later, if they acquire family, it can be transferred. Okay, see, suppose if unmarried person nominated a mother, but it is compulsory. It is compulsory to make a wife as also a nominee under this Act, because later there will be a problem. HR fraternity will face. Better it is the employer should get the furnished details about the nomination details. Otherwise, they will be getting the problem. Next is a nomination may be modified by an employee at any point of time. Yes, Form H. If employee predeceases the employee, sorry, if nominee predeceases the employee, the interest of the nominee shall revert to the employee who shall make a fresh nomination. Next, if fresh nomination or alteration of nomination shall be sent by the employee to his employer, who shall keep the same in his safe custody. So this is about nomination, which is Form G. Okay. Next is inspector. So inspector, the appropriate government may appoint an inspector to enforce the Act. He is empowered to visit, examine, establishment to obtain information pertaining to the Act. He is deemed to be a public servant as per the 21 of the IPCA. Okay, here the inspector will visit every organization where this Act applicable. Okay, and check all the registers, forms, everything. Okay, that is the role of inspector. He is deemed to be a public servant. Okay, inspector may be a labor commissioner, labor officer, assistant labor officer. Okay, it will be appointed by the appropriate government. Okay, next is recovery of gratuity. If the gratuity is not payable by an employer, he shall make an application to the controlling authority where issue certificate to the collector. So even after that, the employer is not paid, is not agreed, then the controlling authority write to the collector. The collector shall recover the amount together with the compound interest. I don't think so. I have not seen anything has happened. Whether the controlling authority has written to the certificate officer, but as Act has prescribed this provisions. Okay, before issuing a certificate, the controlling authority shall give a reasonable opportunity of showing cause against the issue of certificate. Okay, before issue to the collector, again the controlling authority should give a notice to the employer that stating that your the notice will be sent to the collector. Afterwards, the amount together with that, the compound interest will be imposed. Okay. Next is protection of Gratuity Act. Gratuity is not liable to attachment in execution of any decree or order of civil or revenue or criminal code. So yesterday also, Sir was mentioning about PF also is not liable for any code attachment. Okay, that is the beauty of this both the legislation. So they cannot give a decree or code attachment. Okay, next display of notice and abstract of the Act. It is very important for the employers. They have to display the notice of the Act and abstract and rules of the Act. Why is it so? To make the employee aware of the provisions of the Act. That is the reason, in every Act, if you see across all the labor legislation, there will be a separate session is set aside for display of notice and abstract of the Act. So what is the reason begins? So here the employer is communicating that we are complied with the Act, also giving the awareness to the employee. That is the main reason for that. And if there is any changes, that is also ratified. That is also should be displayed, and the abstract should also be English, and also majority of the people understood by the language. Okay, if it is Tamil Nadu, definitely majority of people are understood by Tamil, so they will display abstract in the form of Tamil language. Also English. Okay, next is penalty. So if there is a false representation, 6 months imprisonment or rupees 10,000 fine or both. And if it is non-payable of gratuity, 6 months or 2 years imprisonment. It is if it is non-compliance of any provision, 3 months to 1 year imprisonment or rupees 10,000, 20,000 fine or both. It is there. I don't know whether it is being functioned. Even I have not seen. Okay, any other controlling authority, I have not seen. Okay, they have imposed a penalty, but if you see all the legislations, it is a defaulty mention about all the penalty part. Okay. Thank you. Let us discuss. Before moving to that, I'll tell you, my dear friends, this act may be a burdensome for the employer, but it is not at the case. Here, the act facilitate both the employer and the employee. How? See, it's all a kind of a retention technique. Okay, to make the employee for the benefit of, if you think about the benefit for the employee, to make the employer make the employee retain for 5 years, so that the employer will have some stability in the employment of the employee. Okay, so the case the act both beneficial for the employer and also employee. That is the beauty of this act. Thank you so much. Now it's open to discussion. It's a very small act. That's why we are able to quickly explain everything. Okay, fine. Thank you. Let us discuss.
Okay, sir, thank you, sir. So shall we take up the question, sir?
Yes, sir. Yes, sir.
Okay. Okay. Now there is a question from Pavitra.
Okay.
Greetings, sir. So while calculating gratuity, OT can be excluded or not?
So it's clearly mentioned in the definition. Okay. OT definitely should be excluded from the HRA, OT, and other ones, excluded from the calculation of gratuity. It's very clear, sir. The act has always reckoned with basic wages, basic plus DA. Next.
Okay, sir. So just a suggestion, if you can be closer to mic, I think we can clear you a little more louder.
Now, sir?
Yeah, if you are closer to your mic, it can be a little more louder.
Now, sir?
Yeah, it's fine now.
Okay.
Now it's okay. Okay. Now, Mr. Deepak has asked about some questions. I think he alone has posted 10 questions. First question is about, while calculating continuous service, can I include Sunday or not?
Yes, definitely. There is a case loss, because I'll tell you why. Because it's not a fault of the employee. There's a case loss there on this provision, sir. Definitely, Sundays are also included to deem to be continuous service, because it is not of the employee, fault of the employee. Definitely, sir.
Okay. The second question is, during this lockdown period, workers are not working in the factory or establishment. Okay. Can I count these days as working days for continuous service?
Yes, sir. Yeah, definitely, sir. Because in continuous service, if it is mentioned, there is if there is no fault of the employee, definitely it should be taken to consideration for continuous service. But here we have to take a point of there's an act called two act which is right now imposed for the employer. Okay, there for that they have to pay their salary. Okay, in that case, definitely they are deemed to be a continuous service. Which means they are into the services. Definitely, sir.
Okay, sir. Now, third question is gratuity can be paid in installments?
Sir, actually, there is again the case loss. If it is there is no provision, but it is better avoid not to pay installment.
Okay, sir. Now, fourth question is about if gratuity is mentioned in CTC, whether I have to pay gratuity to the employee, sir, if not completed 5 years of service.
Yes, sir. First of all, I'll tell you, sir, the Act does not prescribe gratuity should be take part of CTC. never prescribed in anywhere. Okay, just because the employer giving a more showing that they are giving more salary, they have included. Otherwise, if they are satisfied with the conditions of the criteria of the gratuity, definitely they should pay, sir.
Okay, okay, sir. Then, if an employee has no family, who is the nominee?
Okay, legal heirs will be a nominee for that employee.
Okay. Now, who is the appellate authority?
Appellate authority will be appointed by the state government, respective government. As I mentioned earlier, okay, it is not mentioned in the act. It's not defined in the act. Okay, so appellate authority will be appointed by the respective state government. In the case of dispute where controlling authority passed an order, both the employee can appeal to the appellate authority, which is appointed by the appropriate government. The appellate authority will hear the both sides and give his verdict, sir. It's a quasi judicial person, sir.
Okay, okay, sir. Now, eighth question is about what is cognizance of offense?
Cognizance of offense normally, okay, without any third person's interference, the act itself take cognizance of the provision. For example, if any employer violates any provisions of the act, it's already prescribed in the act itself take cognizance, which means if they are contravening any provisions, automatically they will be penalized. That's called cognizance of offense.
Offense. Okay, okay. Now,
So I'll tell you one more case. The recent Satan Kulam case.
Sir, can you be closer to mic, sir? Can you be closer to
no,
mic?
Sir?
No, okay.
No, sir.
No,
Is
I think.
okay now?
Yeah, okay, okay, yeah.
Okay, now the Satan Kulam case, court itself take a cognizance of offense. Cognizance. Okay.
Yeah, yeah.
Sumoto, yeah. Likewise, the act is also there. Even maternity benefit act also there is a cognizance offense.
Sir, can I give one more example?
Yes, please, sir.
So, sir, if there is any human rights violation, again, national human rights will take up certain issues, right? No, automatically, without giving any complaint to the National Commission. So, again, that is also called as cognizance of offense.
Yes.
Okay, so it is whether it is applicable or not, that is based on the act.
Yes.
Okay. So, ninth question is about seasonal establishment means working for 120 days or 180 days.
120 days, sir, because in the rules it's clearly mentioned. Just a minute, sir. Just a minute. I won't do that. It's a 120 days, sir. Clearly, it's clear. Yes, it's in the rules. Okay. So seasonal establishment means any establishment which is exclusively engaged in trade fair, circus, so on and so on, and which are seasonal character wherein the work is performed intermediate and not exceeding 120 days during 12 calendar months. It's in the labor department government. But someone also I read, if any organizations work for 7 months, that's also seasonal establishment. Okay, we need some clarity on that, sir.
Okay, okay, sir. Okay.
But yeah, as per the rules, it's a 120 days, sir.
It's 120 days.
Yeah, it's clearly given in the rules.
Yeah. Okay. And one more question from Tibak. If an employee joins the organization after 58 years of age and works for 5 years, can he be eligible for gratuity?
Sir, definitely. Again, there's a case loss. One organization employed a retired person as a specialized person for that organization. He has worked for, it's a 5-year service. In that case also, consultant, consultant, as a consultant. In that case also, the employer is liable to pay gratuity, sir. That's a case law.
Okay. Sir, there is another question from Dr. M.A. Parveen Bano.
Yes,
sir. The government of Tamil Nadu has extended 1 year of service. Will it make any change in the gratuity?
Madam, let us be very clear. This act will be predominantly applicable for only the private sector. Both central government and state government, they have their own rules. So that rules only applicable to the state government employees. So this act will not be applicable. I mean that rules will not be applicable, prevail over this act.
Okay, okay, sir. So now there is a clarification asked from Mr. Rajendran. The recovery of gratuity, the compound interest rate is 9% or 10%?
Sir, actually, it will be decided by the collector and the concerned person. But as of now, I'm not sure about the compound interest, but it is purely discretion of the collectors.
Okay, 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 sir. Then there's a question from Mr. Satish. Is principal employee liable to pay gratuity if contractor does not pay?
A very good question, sir. I was looking for this question for a long time. Okay, here, yeah, is it visible, sir? Principal employer, sir, is it visible? The slide.
Yeah, yes, yes, yes.
Okay, if you just take here, thus far, before this case, principal employer is not liable to pay gratuity. But after this, this case, okay, superintendent engineer versus applied authority, principal employer is liable to pay gratuity if contractor fails to gratuity, which in turn, principal employer can recover amount from the contractor. But this is also a subject of dispute. Some of the experts says this is erroneous judgment, but as of now, I have searched. I also discussed this act. This present case is there, but apart from this present case, with regard to this act, principal employer is not liable to pay gratuity. But after this case, maybe, sir.
Okay, okay, sir. Now there's another question from Ms. Divya Bharati.
Okay.
If an employee rejoins after a gap under a same employer, will he be able to gain gratuity amount
No.
with a year of experience?
Certainly no, sir. That's
Okay.
why the continuous service, there is an inclusion part, sickness, so and so. If there is a gap, definitely no, sir.
Okay, okay, fine. And question from Dr. John.
Okay.
How about applicability of this act in NGOs?
Sir, it's very clear. If any organization has 10 or more persons, this act will automatically be applicable. So if an NGO has 10 or more persons, this act will be automatically applicable. That's my answer, sir.
Okay. Sir, there is a question from Parampreet Kaur. He wants to know the meaning of superannuation.
Okay, there is a two different part. One is this one, retirement and superannuation. Retirement consists two parts. One is voluntary retirement. One is superannuation retirement. So when it's voluntary retirement, automatically they will retire. Superannuation means at the age of attaining the prescribed age. Okay, if it is state government, if they prescribe 58, if any employee attains the 58 of age and retires, it's called superannuation. It is differs from central government to state government, sir. The age superannuation. Superannuation means also retiring from service, but on the attaining of age, which is prescribed by the any government. Yeah.
Okay, okay, sir. Now there's a question from Mr. Satish Kumar. When an employee becomes disabled due to any accident or disease and is unable to do the same work and re-employed on the reduced wages,
Okay.
how the gratuity of such employee shall be computed under the provisions of the Payment of Gratuity Act?
Okay, sir. Thus far, there is no separate calculation, but there is a provision here, computation of gratuity in case of death and disablement. Yeah, if an employee is employed after his disablement, his wages for the period preceding his disablement shall be taken to be wages received by him during that period for the purpose of computing gratuity payable to him. Okay, so before he disables, for calculating gratuity, whatever the salary he received before his disablement, that should be taken account for calculating for gratuity. Okay, and of course after after disablement, he again employs. What is the wages he will be given? That will be taken account is for computing gratuity after he retires after 5 years or so and so. But
Okay.
there is no specified formula for that. But in the act, this only thing is prescribed.
Okay, okay. So now again, there is a question from Mr. Rajendran. Um, what is the benefit for an employee who rendered 4 years service?
Sir,
And he is also asking eligibility for graduate is 5 years, and in that PPT it says 4 years, 24 days also is considered.
yes, sir.
Why there's the two rules?
No, it's not two rules. Because when you take a 240 days continuous service, the court is take a account for calculating the continuous service. That is the reason they have taken the 240 days rules. Okay, if you take a Factories Act, 240 days to attain leave. Likewise, ID Act 240 days continuous service. If anyone has a continuous service 240 days, the court is prescribed this 240 days, which is also deemed to be a continuous service for eligible for gratuity. That is the reason the historical case, because 240 days means he has worked. That's also taken into consideration for calculating gratuity. That is the reason they are mentioned. But as per that, it's 5 years continuous service. That is the reason which I understand, sir.
Okay, okay, sir. Now, Jalani Mohammed has asked.
Can I also checking YouTube now, sir?
Yeah, yes, I can check. But now let us complete this one, and then shall we move on to the YouTube?
Okay, fine.
Oh, fine. Okay, then. Now, he has asked for this. What is the scope of Gratuity Act in the following scenarios? So, scenario number 1: if an employee A is engaged through an outsourced agency or on contract basis for a fixed term,
Okay.
like 1 year. Case 1 is end date of his contract appointment tenure is 13th March 2020, and he has been given another appointment with effective from 31st March 2020 with new terms and conditions.
Okay.
That's the case number 1.
Okay.
What is your answer, sir?
Okay. If same agency employs the same person, they may they may do that gimmick, but if they work in the same employer, it is deemed to be a continuous service, sir. Then definitely they're eligible for gratuity, sir.
Okay.
The employer may may do that all part away for employee, and again freshly they will give a appointment order. The act is very clear, sir. 4 years, 5 years continuous service or 4 years to 4 days. Whoever works in the same organization, definitely this act will be applicable to that employee.
Okay, sir. Then.
Sir, actually, yes, sir.
Yeah.
Tell me, sir. Yes, sir.
Go ahead, sir. You want to say something?
Yeah, I think some of the faculty members are here, teachers are here. Since we are all teachers, whether the apprehension will come, whether teachers also will be applicable, whether schools will also come under the Gratuity Act. Definitely, sir. Gratuity Act will be applicable all schools, colleges, teachers, and professors. There is a case law here. Okay, the case laws for application of the Gratuity Act for the teachers. Primary Teacher Association versus Administrative Officers. It's clearly now all the teachers are eligible for gratuity. Okay, sir.
Okay, sir.
Yes, sir.
Now there's a question from Ramya. Can you give more clarity on compulsory insurance on Section 4A and protection of gratuity?
Okay, compulsory insurance, as I told you earlier, it's the employers liable to tie up with the LIC agency when they reach 500 or more employees. In that case, if they tie up with the LIC, the burden of the burden of liability to pay the gratuity will be reduced for the employer. That is the reason the act they amended the special provisions, compulsory insurance. But in Tamil Nadu, it's not notified. Okay, but in Andhra, it has been notified. What is the benefit for the employer? They can reduce the burden to pay from his own pocket. For that, they have to form the trust, and they have to give a list of names of employees, salary, age. Then the LIC will calculate from the actual science background about the premium for the whole persons. And every year, if any persons goes or comebacks, they have to do only top up. That is the reason behind that the compulsory insurance. Of course, Madras School of Social Work, I was instrumental to bring that. As part of that, to bring the gratuity scheme for our college, that is Madras School of Social Work, and also we have formed the trust. Okay, that is the reason the insurance. But compulsory insurance also same provisions, but it's not notified. Since it's not notified, we have not have any rules for that in Tamil Nadu. Whereas in Andhra, there is a rules. They have that. Next question, sir.
Okay. Now, Mr. Hemant Kumar is asking
No, one more
how
question
an
was
employee, yeah,
there. One more question was there, sir, along with that.
protection of gratuity, sir. No, it was the question was, can you give me more clarity on compulsory insurance and
Okay.
protection of gratuity?
Just a minute, sir.
Hello.
Yes, sir. Yes, I'll come. Okay, sir. Here, what is that? What has happened? Okay, in suppose employee got some amount or borrowed some amount from someone. Okay, and that person, the third person can give a code attachment for his salary or gratuity. In that case, suppose that ex-employee borrows some amount from some person. Okay, in that case, that person cannot attach that amount to get. So suppose if he fails to repay the amount, the third person cannot attach that amount. Number one. Number two, in case of forfeiture, damage property, okay, the amount cannot be attached here through execution of decree or order, civil or revenue or criminal court. That is the importance of this protection of gratuity. So only the gratuity amount can be forfeited. The employee can avail, but no one can suit a degree for that amount by default of the particular person, employee or so on.
Okay, sir. Now there's a question from Mr. Hemant Kumar. How an employee get insurance if he or she belongs to Andhra Pradesh, according to the payment of gratuity insurance?
Sir, actually, I'm not sure about it. If you're working in any organizations, the particular institution definitely would have tied up with any insurance, sir. Then they will definitely, if you are employee, they will definitely would have if you part of the insurance part. If that organization doesn't comply with LIC, definitely they should go with as per the Andhra Pradesh rules, sir.
Okay, okay, sir. There's a question from Sadish Kumar. There is no deduction show in the offer letter or appointment letter for gratuity, and an employee completes 5+ years. Will he be eligible to claim gratuity at the time of relieving or retirement?
Sir, the Act does not say whether it should mention in the appointment order. So, appointment order is it's all incidental.
Yes.
But whoever works 5 years continuous service or 4 years to 40 days, gratuity should be payable, sir. No doubt about it. They may put 4.81% as a percentage of subsidy C. That show that they are paying gratuity. It means they are liable. The employer shows that we are liable to pay gratuity. Okay, that's the reason they are mentioning that. But Act does not prescribe that. That is the thing we have to understand. That.
Okay, sir. Yeah. Now the Act clearly mentions that basic plus DA is calculated for gratuity. My question is, if basic pay is vary from year to year, which basic pay is taken into account to calculate the gratuity? Asked
Sir,
by Divya Bharati.
That's why last on salary, when they retire, okay, what is the last on salary that will be taken into consideration, sir? Whether it is varied to every year, what is the last on salary? That year, what is the basic pay has been changed? That will be taken into account for calculating gratuity.
Okay. A question from Mr. John Shyam. If an employee is superannuate retirement and still continues to work, gratuity will be calculated till 50 years of age or till his LW in the company?
Sir, I don't understand the question, sir.
Now, if an employee is superannuate retirement and still continue to work, gratuity will be calculated till 58 years of age or till his superannuated period.
The age doesn't come into for calculation of gratuity as long as he is working with organizations. There's a case laws against for this, sir. It's like also a hiring consultant. Even if they continue, that year also should be taken into consideration, sir. That's a case law. Case law is there.
Okay. Then there's a question from Mr. Rajan Kumar. Calculating payment of gratuity, why they taken 26 days for non-seasonal establishment and for seasonal establishment only 7 days? Why?
Sir, here in a year 30 days. Okay, Okay, 26 days they are taken as a default. If you ask me exactly, I don't know the answer because the Act prescribes that. Okay, 26 days, the working days. Okay, leaving off 4 Saturdays, Sundays. That is the reason they are taking 7 days. But seasonal establishment, because since it's working for 120 days, okay, that's the reason they have taken 7 days, sir. But if you ask me exactly, I don't know answer, but the Act prescribes this one, sir.
Okay. There's a question from Nikita. If special allowance is not given uniformly among the employees, will it be considered under wages for a particular employee?
Sir, I'm very clear, sir. The Act also clearly defined only basic plus DA. Leave off all the special allowance, bonus, OT, commission, so on for calculating gratuity. But when it comes for, if you ask me special allowance, it should be uniformly should be given. That's a question, one of the MCQ questions for yesterday's PF Act. That's called special allowance.
Yes. There's a question from Mr. Ram Mohan Naidu. If the employer doesn't apply for gratuity immediately after his resignation and apply after some time, let's say after 2 years, will he be eligible to get gratuity? Suppose if his employer doesn't pay, what is the case?
Very good, sir. Actually, 30 days, okay, it's a prescribed time. Okay, after 30 days, after 60 days, after 1 year, the employer can entertain the application, but provided there should be reasonable that should be valid reason for delayment for applying the gratuity. Even that is there is no valid reason for that, it is a responsibility of the employer to pay gratuity, sir. It's very clear in the Act.
Okay. Okay. Now there's a
At any point of time, he cannot claim gratuity. So in that case, what the employer is supposed to do, no? After calculating the gratuity, that is the reason they are giving notice to the controlling authority for addressing this problem. No, the employee will come after 2 years or 3 years. In that case, it is better the employer should calculate the gratuity and deposit the amount to the controlling authority. It's better, sir.
Okay. Okay, sir. Now there's another question from Deepak. Please tell the case study for employee joins after 58 years of age are eligible to receive the gratuity.
Actually, I have not mentioned any. Actually, I don't have that. It is not the PPT. It's in the book. Okay, I couldn't locate right now, but there is a case I'll send across later. For example, one of the case that they hire a consultant after 58 years. He has worked for 5 years of service. Then he applied for gratuity. The court categorically says he's eligible for gratuity. I'll give you the case later, sir. It's in the book.
Okay, sir. Now there's a question from Mr. Karthik. The employer has submitted nomination form before his marriage, which happened 5 years before. He passed away. Now the nominee, as per the nomination, is mother, but wife is raising the dispute. What should have been done for this case?
Okay, sir. So 5 years, say if there is fresh, that's the reason Act prescribes the fresh nominee. Okay, and if employee deceased, and okay, I'll show you the nomination. Okay, there is a provision for that. Yeah, if nomination may be modified by an employee at any point of time. While making nomination, if a person doesn't have nominee, he or she make any person later. If they acquire family, it can be transferred, sir. In case of employee dies, and while he while he would have given the nomination, he would have mentioned about who's the nominee. Okay, in case if we give us a nominee as a wife, then of course it should be automatically will be given to the wife. Even if there is a dispute, okay, the employer normally will do proportionately will give the amount, and if it is more dispute, it's better to go for the controlling authority. It's better.
Okay. Now the same person has asked one more question, sir. Because of dispute between the family members regarding the nominee, the employer has delayed the gratuity settlement. 10% simple interest is still applicable.
Yes, sir. That is the reason, sir. It's better the employer should deposit the amount to the controlling authority as soon as the employees gets over. Otherwise, the 10% interest will be levied on the part of employer because they have a dispute. But if because of the dispute, they wouldn't have get the amount from the employee. It's better to deposit the amount if there is any dispute. to the controlling authority. The controlling authority will sort out disputes, sir. Because the head, as long as the employer, it's better to reduce the headache and throw the ball, pass the ball to the controlling authority. That is the reason the controlling authority is there, sir.
Okay, okay. Now there's a question from Ms. Pavitra. Will 26 weeks of maternity leave count for gratuity?
Certainly, sir.
In fifth year, he or she was on maternity leave.
Certainly, certainly.
Yes.
So that is one of the inclusion criteria for continuous service.
Okay, okay, sir. Now, question from Ms. Malini. Can you explain about forfeiture of gratuity, section 4.6?
Sure, definitely. Okay. So when employees forfeiture of gratuity, okay, right is a disorderly conduct, any other act or violence on a spot, any act which constitutes an offense involving moral turpitude. Okay, if any employee involves in the disorder conduct or immoral happenings or willful omission or damaging the property, okay, in that case, to the extent the employer can proportionately the loss for the property can reduce the gratuity. But when the completely denied, what is the forfeiture means? Denial of the gratuity. Okay, it's the rights of the employer. Okay, as long as he has obligation, he has also right of the employee because he's employed the employee. The employee is supposed to act in an order. There's an order, a disciplined way. Okay, if he involves any theft, okay, any other things, then that it is a right of the employer to forfeit, to deny the gratuity. Okay, for the denying the gratuity, for that the employer has to follow certain procedure. First, if it is moral turpitude, in consider offense. So note this word here. I underline the word offense involving moral turpitude. In that case, gratuity can be denied. Gratuity can be denial. Okay, and also one more point is there must be a termination of order should be given for denying the gratuity. Okay, for everything is case by case. Principles of natural justice should be complied. Okay, so in the case, if take example as okay, I'll show you, sir. Just a minute, sir. I'll show you this case. Yeah. So if you take that same case over here, madam, the facts of the case is respondent is a branch manager in Union Bank. Is it visible, sir? Is it visible,
yes, sir? Yes, sir. Yes, sir.
Respondent is a branch manager in Union Bank and disciplinary proceedings were initiated against him on the misconduct proved against him, and the acts of involving monitoring the following are changes. Failure to take all steps. These are the facts. Okay, if you could read. A court held that though the learned counsel for the appellant bank has connected that conduct of the respondent employee, which leads to framing of the charges in department proceedings involves moral turpitude, we are afraid the contention cannot be appreciated. Why? It is not the conduct of person involving moral turpitude that is required for forfeiture of gratuity, but the conduct or the act should constitute an offense involving moral turpitude. To be an offense, the act should be made punishable under criminal law or any law. That is absolutely in the realm of the criminal law. It is not for the bank to decide whether an offense has been committed. It is for the court. Court has to decide, okay, whether it is a moral turpitude, and law, criminal law, criminal or offense. The court has to decide. Okay, that is the reason it's very clear. In the present case, there is no conviction of the respondent for the misconduct, which according to the bank is an offense, because failure to take all steps to ensure and protect the interest of the bank, failure to discharge of duties of utmost devotion diligence. If you take that, whether it's offense, the court has to decide whether it's offense, okay, under the criminal law. With regard to this case, it is not offense. That's why the automatic dismissal, automatic forfeiture of gratuity cannot be entertained here. That's why, in my slide, in the forfeiture of gratuity, I have mentioned here, I'll close here. Forfeiture of gratuity on dismissal of service is not automatic. It's very clear in the Supreme Court judgment, the same court judgment. Yeah. It's clear. Am I right,
okay,
sir?
Yeah, yes, sir. Yes, sir. So there's one more question from YouTube participants.
Okay.
Mr. Dinesh Kumar is asking, if an employee works for 5 years, during his third year, he worked only for 140 days. whether he is eligible for gratuity.
5 years.
He has worked
Okay.
for 5 years,
Okay.
but during his third year, he worked only for 140 days. Whether he is eligible for gratuity.
140 days, no, sir. 240 days should be there, sir. Even if you calculate 240 days, for let's take an example, sir. If any employee is gone for sickness, so 30 days. So what is the eligible for gratuity? 240 days, he has to work in a 1 year. Okay. So 30 days, which means 210 plus 30, 240. That is will be taken into consideration. But 140 certainly no, sir.
Okay. Okay. I think it's the
Likewise
last.
for any other inclusion criteria, sir. Even for layoff, dismissal, or any other things, the interrupted days should be calculated for the number of days actually has worked to make it part as a continuous service. That's why maternity benefit 26 weeks. Okay, I think two for how many days? 180 days or something like that, sir. That's also taken into consideration for calculating gratuity. Yes, sir.
Okay. I think is the last question from Ms. Pavitra. Can an employer give excess gratuity to the employee? How much amount of gratuity is free from tax liabilities?
Okay, up to 20 lakhs, it's non-taxable. If employer is willing to give as part of loyalty, as ex gratia, employer can do so, but it is taxable as per the section 10 of the Income Tax Act. But I don't know what is percentage of the amount, but it is taxable if he gives as a gratuity more than what more than the ceiling limit as part of ex gratia.
Okay. Okay. I think that is that's all the questions that we have got so far, and YouTube also participants also have asked only one question. So I think Q&A session is over. Now I may ask Swarnima Rao or any other question that the participants have, because time is only 4:38. If you have any other questions, you can unmute yourself and then you can ask last two questions.
And sir, suppose
Yeah, very good.
yeah, sir. Actually, I want to just share something. I'll share it here. Here. Yeah. See, many of them might be wondering, so how to payment of gratuity in case of death of employee. The Act does not prescribe any how to calculate gratuity in case of death. But there is a source which I have taken up from these two sources. So when the death of employee, so these are the amount payable, but the Act does not prescribe. But in the Code of Social Security, it is mentioned the so-called is about to come or 2 years. It is mentioned in case of death or disablement. In case of death, the calculator will be calculated on pro rata basis. But over here, they have done. They have given this table. Okay, less than 1 year, 200 basic salary. But I have not seen any act to calculating gratuity. But the employer has to proportionately give a gratuity amount in case of death. Okay, sir. That's what I want to share here.
Okay.
That's it, sir. Thank you.
So there's a question. Can we get the email ID of the faculty?
Sure, sir. Sure, sir.
I think we will share our email IDs at the end of course. So you will get it soon.
Sir, actually, Deepak Tinivaran actually mentioned here. Actually, payment of gratuity is in dispute in the Supreme Court. So let us wait, Deepak sir. Let us wait for that, sir. We'll wait for that judgment, sir. But let us keep it like that, sir. Apart from this case, principal employer is not liable to pay gratuity under this act, sir, defaultly. But only this case has come. There will be a sudden disruption in the people. Okay. Thank you, sir. Thank you.
Okay. Okay. I think. Yeah. Well, sir, one more question from Mr. Ram Mohan Naidu. For calculating of gratuity, which date of joining is taken into consideration, whether as per this appointment letter, PF, or his original date of joining, which is nowhere mentioned in the records, because most of the contractors change date of joining of his employees every year so as to avoid to pay gratuity.
Okay.
I think it's for the contract employees.
But sir, in my knowledge, it's better the contractor should maintain all these things. But to prove that, if they have a bank statement, I mean the salary statement, if they have that from that point of time, we can take into account. But if they don't have, we cannot help it out. But please reserve this question. I think tomorrow Labor Commission is handling session. We'll ask the same question to him. We'll get the answer, sir.
Okay. So I think that is the end of Q&A session, sir. So no more questions from
Okay, sir. We'll stop it.
participants. So stop with this. Now may I ask Swarnima Rao to propose a vote of thanks.
Yes, sir. I thank Professor Hemakumar for taking his time and imparting his knowledge with us. I thank all the participants for their involvement and their willingness to take part in this course and for their active participation. I hope you all had a great learning session today. Thank you.
Thank you, Swarnima Rao. And thank you.